Hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeet Bhatia again, and we are back with a new video for your legal affairs for CLAT and AILET. Right, so now starting from the first thing, if you are new to this channel, don't forget to click on the like, share, and subscribe button, and also don't forget to click on the bell icon for all these regular updates. Now, the first news for the day is that there is a long-standing domestic dispute committee that was constituted, which says that mental cruelty to spouse who intends to live in peace. Right now, there was a dissolution of an appeal filed by a husband alleging cruelty at the hands of his wife. The Madhya Pradesh High Court has recently observed that the long-standing dispute itself is a mental cruelty to a party who intends to live in a domestic relationship and peace. Okay. Now, what was happening that the husband submitted that his wife and him got married in 2004, and soon after their marriage, his wife compelled him to change his house, and therefore he had to part with his parents and had to live with his wife in a nuclear family for domestic peace. Now it was further submitted that out of their wedlock, two sons were born, out of which one was 14 years of age at the time of filing the application, and the another son passed away at the age of 3 due to the alleged negligence of the respondent's wife. Okay. Now, what did the court say in this matter? It said that when the appellant specifically pleaded about the behavior of the respondent for last more than 15 years in different stages of dispute and reconciliation, and complaints from a long time to time were referred, which indicated that both shared domestic incapabilities. Right, it appears that for very long time parties shared domestic disputes and irreparability and mental cruelty inflicted by the wife over her husband through her conduct and through her denial for cohabitation. In absence of any cross examination or rebuttal, allegations of appellant assume importance. Right, so that is something which is very important here, that if there is a long standing domestic dispute, it constitutes to mental cruelty for the spouse who wants to live in peace and also have a happy home for himself. Now, coming to the next part is that people or employees who are appointed on contractual basis without public advertisement does not have the right to regularization. That's what the Punjab and Haryana High Court has said, that employees appointed on contractual basis without any advertisement and contrary to the provisions of Article 14 and 16 of the Constitution of India do not have the right to regularization. Now, there was a bench that comprised of Anupinder Singh Gerwal, thus dismissed the petition that was filed by the respondent as a driver for 3 months. His services were extended subsequently, but the services were dispensed by an order which is challenged by the petitioner, stating that the same word passed without affording an opportunity of hearing to him. Now, certain court placed reliance on cases of Punjab Water Supply and Sewerage Board versus Ranjot Singh and others, and said that KV Ramanna and others wherein it was held that employees appointed on the contractual basis without any advertisement and contrary to the provisions of Article 14 and 16 of the Constitution of India have no right to regularization. They cannot go and ask the person that they need to be regularized or their employment needs to be regularized, or they don't have any right of that sort. Right, so that's what the court has said very clearly. That is the Punjab and Haryana High Court. Now, coming to the next news for the day, that the police officer is not obliged to register an FIR on information about the offense that is likely to take place. If you go and tell the police that this offense is likely to take place, so the police is not obliged to register an FIR on the information about the offense. Now, it was clarified that the mandate under Section 154 for registration of FIR comes into picture when cognizable offense has been committed. Justice Srinivas Harish Kumar said it is not necessary to register FIR whenever a police officer receives information over the phone or in some other way about an offense which is likely to take place. Rather, it is the duty of the police officer to take immediate measures to prevent the crime from happening, or if it is committed in his presence, to take action according to Section 41 of the CRPC, FIR may be registered later on. Now, the argument that was taken and rejected by the court, stating that it has clearly laid down that whenever information disclosed of commission of a cognizable offense, registration of FIR is mandatory. Now, in the sentence in the section 154(1) of CRPC commences thus: every information related to commission of cognizable offense, that means by the time information is given to the police officer, an offense should have been committed. It is in this context that Lalita Kumari obliged the police officer to register FIR first before taking up the investigation. Registration of FIR is a mandatory requirement to rule out the possibility of embezzlements, improvements and exaggerations of event in course of time. ठीक है. So अगर कोई event likely to happen है, उसके ऊपर आप FIR नहीं दर्ज कर सकते. You cannot register an FIR for an event that is likely to happen. Okay. Now coming to the next news for the day, that is that being an Indian citizen, every girl has the right to live peacefully. That's the MP High Court refuses to quash POSCO case based on compromise. There was a certain compromise that was done in a POSCO case. So the MP High Court refuses and says that being an Indian citizen, every girl has the right to live peacefully. Now coming to the next news, that is that Russia is suspended from Human Rights Commission Council and India is abstaining from voting, and that is creating a lot of international news nowadays. Now the Human Rights Commission Council vote result says that Russia was suspended from the UNHRC, that is the United Nations Human Rights Council, over the reports of gruesome violence committed by Russian troops in the cities of Ukraine and particularly in Bucha. Now, Russia was suspended from UNHRC after the 193-member assembly adopted the resolution and voted against the country that invaded Ukraine in February 2022. Notably, India abstained from voting against Russia in UNHRC, making itself clear on the diplomatic stand amid the Russian-Ukraine war. Now, there was a resolution that was passed titled Suspension of the Rights of the Membership of the Russian Federation in the Human Rights Council was adopted with 93 votes in favor, 24 against the suspension and 58 abstentions, including India. So India didn't vote in this matter. It abstained from voting on such a matter, and it took a back foot on such a matter when there was voting going on against Russia in the Human Rights Council. Now, there is a criminal procedure identification bill of 2022 that is being passed, and Lok Sabha has passed the bill. Know what power it gives to the police. Now we are going to discuss that. Now the Lok Sabha passed the CRPC identification bill of 2022 on April 4th of 2022. The bill will allow the police to collect measurements and biometric samples of all detainees, such as fingerprints, palm prints, footprints, iris and retina scan, physical samples and behavior attributes, including handwriting and signatures also. The police are currently permitted to only take footprints and fingerprints impressions of a limited category of convicts and non-convicted person. Now, the bill was passed through a voice vote in Lok Sabha. After a discussion under the bill's provision, the measurement record shall be retained for 75 years from the date of collection. Now, during the discussion on the bill, the Union Home Minister Amit Shah also said that there are techniques that are being improved to handle the new generation crimes. He said there will be provisions that will be used only in cases of heinous crimes, which was one of the amendments proposed by the opposition MP. Now, another MP had proposed an amendment to clarify that the samples will only be taken from convicts and not from those who are detained. The Home Minister has assured that the necessary clarification will be made in the rules. Now, what is the Criminal Procedure Identification Bill exactly saying? Now, the Criminal Procedure Identification Bill of 2022 seeks to repeal the existing Identification of Prisoners Act of 1920, which is limited to allowing the collection of finger and foot imprint impressions and photographs for a limited category of convicts and non-convict persons on the order of the magistrate. Now, What does the Criminal Procedure Identification Bill of 2022 gives to the police? Now it is going to take measurements of conviction and other persons for the purpose of their identification and investigation in criminal matters to preserve records. Now, while Identification of Prisoners Act of 1920 allows collections of measurement for only a limited category of prisoners, the new Criminal Procedure Identification Bill of 2022 will allow police and or prison officials to collect measurements of all those who are detained under various charges or even those under preventive detention. It will give the police to take physical and biological samples of all the detainees, right? So it is more about taking the sample, photographs, fingerprints, retina scans. All of these things will be done in the Criminal Procedure Identification Bill and the changes that are being done. So that's it for today, guys. Thanks for joining this live session. I hope you got some legal affairs for this week very, very clear. And I hope you enjoyed the video. So don't forget to hit on the like, share, and subscribe button. And do make sure that you subscribe to our Telegram channel under the name of CLAT@Pratham. Thanks for joining this live session, guys. Have a great day ahead. Keep smiling and keep preparing.